welcome everybody. Thank you so much for joining. My name is Geoffroy. I'm in charge of the product here at Proxyclick. And today we will talk about data privacy and the impact of the COVID crisis on data privacy. So to set the scene and before introducing the other panelists, let me just start by explaining what were the three main impacts of COVID on Proxyclick's activities. So our business has always been historically to help companies track their visitors in order to protect their workplace. And there was three main impacts of the COVID crisis. One, the first impact is that suddenly companies required much more sophisticated screening process for their visitors, typically involving medical health questions to screen employees before they come on site. So as a result, we developed a few features in that direction. Two, very important, suddenly the workflows that we were building since years for visitors, suddenly those workflows became very relevant for employees, which was not really the case in a pre-COVID world, because employees as visitors can be a danger, right? And carry the virus with them. And the third big impact is that the privacy question, which has always been very important to us because our client process a lot of very sensitive information, that relevance was even more true in COVID times, because suddenly we were also dealing with quite sensitive answers on quite sensitive questions. So this is why I'm very happy to have together with us panel of experts when it comes to privacy questions. And so I propose that the three other members of the panel introduce themselves, maybe starting with Jarno.
Okay, hi Geoffroy. Thank you very much for the introduction to this panel. My name is Jarno Vanto. I'm a partner in the New York office of Crowell and Mooring, partner in the cybersecurity and privacy group. And over the last spring and summer, I've been working a lot on COVID-19 related privacy and personal information related questions, and happy to be a part of this panel today.
Good afternoon all. My name is Frederik from Remoortel. I'm a partner in the Brussels office of Crowell and Mooring. I work on corporate, commercial and data protection matters, and I've been working with Proxyclick for a few years now. Also helped them at the time when the GDPR was introduced, and so I'm very happy to now be a part of this panel.
Hi everyone, I am Stefanie Tack, Counsel in the Brussels office of Crowell and Mooring. I am a member of the Labor and Employment Group, and I advise clients on all aspects of individual and collective labor law, but also on privacy and data protection topics. And during the COVID-19 pandemic, of course, we received a lot of those kind of questions, and I'm very happy to be part of this panel today.
Okay, great. So we have a mix of US and EU expertise, and I think that's very relevant for the audience because we also have a mix of companies from everywhere. And sometimes the answer to a question can have a regional aspect because things are covered differently. So maybe let's start with a quite general question. What do you see as the key data privacy challenges or changes that were introduced by the COVID-19 crisis?
There are obviously many challenges, but one of the biggest challenges for a company operating in the US, particularly when it comes to employees, is that the privacy challenges depend on which state you operate in, on the one hand, and on the other hand, they also depend on the technology adopted for purposes of, for example, contact tracing and tracking of employees. When it comes to visitors, again, there are state-specific differences. Helpfully, though, the Federal Equal Employment Opportunity Commission and the Centers for Disease Control have both issued guidance for companies, and many elements of this guidance form a backbone of the state-specific mandates around COVID-19 tracking and tracing. So there are some commonalities, but really it comes down to which states or state you operate in.
Yeah, from a European point of view, I think more generally, we are of course faced with a global health crisis that is unseen for people of my generation and generations before me. And so the existing legal framework has actually not changed, data protection laws and labor and employment laws, but these have to be applied to a very extraordinary situation, and a situation that a lot of these laws have not been written for. I think that is really a challenge. I mean, there are certain countries where you have specific laws around COVID-19, but still the general existing legal framework is there and has to be applied. So I think that is really a challenge to apply laws which have not really been written for this extraordinary situation. Now, I think from a purely data protection law perspective, and maybe Stefanie can say a little bit about labor and employment law, but from a data protection perspective, we have, of course, also to take into account the various national data protection laws in addition to the GDPR. And we also have to take into account the fact that the GDPR is actually talking about a fundamental right. Data protection in Europe is a fundamental right, but that needs to be balanced against public health, protection of health and safety, which is also a fundamental right. People are protected, their life is protected, their health is protected. And so you have this balance of two fundamental rights. So you have legislation about data protection, you have legislation about health. How do you combine those? And so I see a challenge in how companies will react when they want to combat COVID-19, because of course they want to protect individuals, they want to protect their employees, they want to protect their visitors and avoid that people get ill on the one hand, but on the other hand, the data protection rules, which they have also to comply with and which are a fundamental right. So that is a challenge between health and data protection. There's another challenge that I see, but that's one I think we will not discuss today, is the challenge about everything that concerns cybersecurity around COVID, because we have now much more employees working from home, the teleworking, and so there you also have a challenge that there is an increased cyber risk, but that's not really, I think, the topic of today. So that was everything about data protection rules specifically. Maybe Stefanie, you can tell a little bit about specific labor and employment law and what the challenges are there.
Yes, indeed. So as part of this introduction, and then specifically with regard to the relationship between employer and employees, it is important to emphasize here that in Europe, most employers have a right to exercise authority over employees, which means that they can take measures, give instructions to employees, but also that they can verify if these employees comply with these measures and instructions. But in addition to that, it is also important to mention that in most European countries, employers have a general legal obligation to provide a safe and healthy workplace, and that they are responsible for the monitoring and the evaluation of health risks at work. And now due to the COVID-19 pandemics, employers are indeed confronted with a new risk at the workplace, and that's a possible contamination with the COVID-19 virus at work. So the legal obligation of many employers in Europe is that they need to take the necessary measures, and they must implement such measures in order to avoid a contamination with the COVID-19 virus. On the other hand, what is also important to mention is that employees themselves also have a legal obligation not to endanger the health of their employer, their colleagues, but also third parties who visit quite often the workplace, like external consultants, contractors, etc. And employees, they have thus an obligation to cooperate with the employer in order to enable the employer to fulfill its legal health and safety obligations. And in the fight against the COVID-19 pandemic, employers can and even must take various types of measures. There are so many measures, for instance, very general measures, implementing a general teleworking scheme, or even implementing organizational measures such as implementing flexible working time, installing hand sanitizers, wearing face masks, etc. But some of the measures, and those are the measures that we will discuss today, for instance, measuring of body temperature, have already proven to be very controversial in terms of their risks of violating privacy rights of employees, and some other measures also involve the processing of different types of personal data. And we will discuss that more in detail, but this shows that the main question here is that how do the legal health and safety obligations of the employer and even of the employees relate to and or have an impact to the right of privacy of the employees of the company. And since the start of the COVID-19 pandemic, there has been this discussion whether the protection of the fundamental rights to privacy of employees should be set aside during the pandemic in order to enable the employers a more effective response to the COVID-19 virus. And it's true that the right of privacy of employees is not unlimited, and that has been confirmed not only by the European Data Protection Board, but also by the Council of Europe. And I think that's also what my colleague Frederik said, is that there should always be a balancing of the interests involved. The Council of Europe has emphasized that privacy and data protection can in no manner be an obstacle to saving lives, but there should always be a balancing of interests, of the interests at stake. And you will see that this will be often discussed today during this session.
Okay, fantastic. So indeed, what we see through your replies is that it's not an easy question, and that there are multiple lenses and dimensions to consider. I see at least three: the purpose, health versus privacy; the geographical dimension, what is true in one country may not be true in another one, and even at state level in the US. And the third one is also the person we're talking about, because there seems to be maybe differences between what you can do and cannot do for a visitor and for an employee. So let's try to be a bit more specific and look at a concrete use case. So what we see is that a lot of companies, they rely on screening the people who will come to visit them, being it employee and visitors. They tend to ask them questions in advance because they want to eliminate the risk as soon as possible. So a lot of companies now ask typically health-related questions to employees and visitors before they come on site, and based on their answer, give them, for instance, a QR code to access the building, or ask them to reconsider their visit and maybe do it online. So companies using that or wanting to use that, suddenly they must set up a list of questions to be asked to their visitors or even employees in advance. And that's a very concrete privacy question. And so my question is, in this kind of health-related pre-screening, what do you need to consider? What can you ask? What can you not ask? What do you need to take into account when you ask these questions to be on the legal side? Anyone wants to start answering this question?
Yes, indeed. This question is raised by many employers. To what extent they can, via questionnaires or oral questions, ask employees or visitors whether they have made private trips to, for instance, high-risk countries or red zones, and whether it is also possible via questionnaires or an oral questioning to ask questions with regard to the medical situation or health status of our employees and visitors. In general, and if we look in normal circumstances, those kind of questions are not possible, because that kind of information is private information and is protected by the right to privacy. Of course, we are now in a specific exceptional situation, the COVID-19 pandemic. And if we look, there are different positions of the various data protection authorities in Europe. And some DPAs have a very strict positions, others are more pragmatic. If we look at the strict positions, which are, for instance, France, Germany, Belgium, and Spain, the DPAs, they stress that an employer cannot oblige the employees to fill in questionnaires relating to travel, and that it's recommended that the employees be encouraged to spontaneously report on risky trips. So basically, according to those strict positions, questionnaires about recent travel are only allowed on a voluntary basis. These strict views seem to us to be open to discussion, because they do not take into account, for instance, the legal obligations of employees themselves to not endanger the safety of the employer, colleagues, third parties, visitors, etc. So consequently, in our view, employees may be requested to disclose some information about their private travel, insofar as this can be relevant in order to enable an employer to take necessary measures. There are, of course, other EU countries that have a more pragmatic approach. It concerns Italy, the Netherlands, and the UK. And as an example, I refer to the position of the ICO of the UK, who in its recent recommendation recognizes, especially in this COVID-19 pandemic, the need to process data in order to provide a safe working environment. So instead of simply refusing the measures using questionnaires about travel and also health data, the ICO confirms that you must only ensure that the measures are necessary and proportionate. And here for questionnaires, the ICO says that self-reporting in the form of questionnaires is indeed one of the least intrusive measures that an employer can take, and thus seems reasonable and proportional, and it's the same. And with regard to health and medical information, the ICO has the same position compared to the other countries who have a more strict position, like France, Spain, the Netherlands, and Belgium. They clearly have the position that employers cannot oblige their employees to fill in medical questionnaires, and that medical and health information can only be provided by the employees on a voluntary basis to the company doctor, not even to the employer, but only to the company doctor, and that even if employees share medical and health data with the employer, that the employer cannot process such information. And with regard to that health and medical information, we are of the opinion here that, again, we should verify how the right to privacy of the employees relates or has an impact on their duty to cooperate with the health and safety policy of the company. And there we see indeed that the French DPA, and that shows that they are open for some more pragmatic approach. They say that even though medical questionnaires are not allowed, employees working in close contact with colleagues or the public or visitors, external consultants, etc., they have a legal obligation to inform the employer in case of a contamination or a suspicion of contamination. So that means that even if they don't allow medical questionnaires, there is an obligation for the employees to provide information when they have when they are infected with the virus, and when they have a suspicion of contamination as well. And for visitors, it's a little bit the same. The companies that the DPAs that already have a very strict position for employees. In general, they also say that companies cannot oblige visitors to complete questionnaires. In other countries, we see that the position of the DPA is less strict for visitors, that indeed questions can be asked to visitors, but only orally, and that the answers to the questions cannot be registered and processed. And then other countries, again, UK, Italy, they allow questionnaires for visitors.
So when it comes to employees, in the US, we have a statute called the Americans with Disabilities Act that regulates, for example, the confidentiality of certain employment records and inquiries relating to disability status of employees. And COVID-19, based on the most recent guidance, obviously any of the guidance related to COVID-19 is very recent. And so they could be considered disability for purpose of the ADA. And so most states, when it comes to, and most employees, when it comes to any questionnaires applicable to employees, follow the ADA related guidance from the EEOC. And the discussion around what types of questions you can answer from employees in the United States hasn't really revolved around privacy. It's more that employees have an obligation, and therefore, if they fail to meet that obligation, liability to create a safe work environment. However they get to that safe work environment, if part of that includes an inquiry into, for example, the whereabouts of an employee outside the workplace or any travel, all of that, the employers are obligated to ask those questions. And then many states have, for example, issued guidance around to companies operating in those states around these inquiries. And so again, it's a state-specific question with federal guidance. But here, particularly when it comes to these questions asked from whether it's employees or visitors, the questions have, the issues that have been raised have not revolved much around privacy. Although California, which has the broadest of state privacy laws in the United States, called the California Consumer Privacy Act, it does, even though the CCPA exempts employee personal information from its scope until 2022, it doesn't exempt businesses from notice obligations, including those employer obligations to notify its employees about the company's data collection practices. So again, if you're operating in California, whether you're dealing with employees or visitors, you're still obligated to, for example, notify them about your company's data collection practices, including COVID-19 related practices. And we're going to get to those questions relating to testing and temperature checking and vaccinations later. But the ADA does require that any medical record collected in connection with the person's employment, the confidentiality of it must be maintained, which means typically that, for example, these questionnaire answers and any tests must be kept separate from a person's regular employee file, meaning that, for example, that it can only be accessed by individuals, for example, that have a responsibility to ensure the safety of workplace, maybe not regular HR personnel, all of that. So again, it's a confidential medical record.
Okay, thank you very much. So as we see, depending a bit on where you are, yes, we can collect some information through questionnaire to screen people, being it employee or visitor. So we already discussed it a bit, but I'm interested in the how. When it's allowed, how does it need to be done? And you spoke about giving a notice. There is also consent also applies here. Is there something specific about how long you can keep this type of information? So when you can collect this information, and I'm not here talking up too much about really very sensitive data like temperature, but more about questions about travel and about whether you felt sick. Is there anything on the how that we need to take into account?
Yes, I think under EU law, if you want to process certain data, so collect it or store it, or even just listen to it in order to then take decisions, you need to have a legal basis for that. And that can be the performance of a contract. You need to do that because you have a contract with someone, or it can be your legitimate interest to do so. It can also be the consent of the individual. Now, when we're talking about COVID-19, very quickly you are treating health data. So when you mention temperature, okay, that's health data. But even if you say where were you and did you get infected or not, is also health data. So you quickly become into the area of health data, and there you have to know that under EU law there are more strict rules to have a legal basis. It's not just, you cannot say, okay, it's my legitimate interest to do so. No, you need to have one of the criteria which is listed in Article 9 of the GDPR, where it says, in these circumstances, you can process health data. And so one of the possibilities is the explicit consent of the individual. So indeed, for health data, explicit consent is the best way to do it, where maybe Stefanie can also mention that, but in some countries in Europe, there are doubts whether you can indeed obtain a valid and free consent of an individual, in particular an employee, because an employee, of course, is this relationship of authority towards the employer. So can an employee give a valid and free consent? That is contested in various countries. Even for visitors, you could say, okay, is this a valid consent? Because if the person concerned does not consent, then he cannot enter the building. But again, I mean, it has to be evaluated on a case-by-case basis. And there are, of course, other reasons where you could process health data. For instance, indeed, as Stefanie mentioned, in many countries you have systems where you have a doctor that is connected to the company and that by law has the authority to examine employees. And so in the framework of an examination by a doctor appointed by the employer, you could of course do these checks. But I think that's important to know that we are talking very quickly about health data, and so you would need consent. In addition to that, the normal rules of the GDPR and of the national laws will apply. For instance, when you do a certain data processing, you have to inform individuals. So indeed, if you say, I ask your consent for a questionnaire, or ask your consent to process that you confirm that you have not been, that to your knowledge you're not infected, you also have to inform the individuals via privacy notice, and you have to say, okay, how long will I keep this data? Who has access to the data, etc. So that is the information that has to be provided under the normal rules. I don't know, Stefanie, whether you have any addition specifically from a labor and employment point of view on this question.
Maybe a few points. Indeed, consent in the employment relationship, as Frederik mentioned, is very often set aside. So many European countries confirm that employees are not able to freely give their consent when it relates to their health data, etc. But there are even countries saying that visitors in some certain situations are also not free to give their consent. For instance, if a driver comes to a company to deliver a package that was ordered by the company, and that prior to be able to enter the premises of that company, that he has to complete a questionnaire on his health situation, that even then he's not able to give a free consent because he has his own employer forcing him to do his job and to make it possible to deliver the package. So even in that situation, there are countries saying that a visitor of the company is not able to give his free consent, and therefore that it's not a legal basis to obtain and process certain information received from a visitor. Another point is maybe with regard to the access to the data, who has access to sensitive data such as health data. Well, as Frederik mentioned, the general rules of the GDPR applied. It is important not only to provide for adequate protection or to adequately secure the health data, but also to restrict access on the basis of the need to know principle. And if we look at sensitive data, is that such health data is often limited to persons bound by professional secrecy. For instance, again, the company doctor. So that's also important when it comes to processing of health data, sensitive data.
Going a bit further on that topic, we also gathered some questions that I'm seeing now, which ask a bit how far can you go with very specific questions. And I want maybe to highlight 4 of these questions, and if you could give your input on these, that would be great. One is, can you refuse entry of a visitor who refuses to answer the questionnaire in the area where you can have such a questionnaire? So can you refuse entry because someone just doesn't want to fill it in? The second one that I have here is, can you scan the temperature of everyone entering your building? Can you do that? The third one is, if a vaccine is available, can you require vaccination from your employees? And the fourth one is, can you even terminate an employment agreement of someone who refuses to take a test or to take vaccination? So a bit going higher in irradiation in the examples, but those are questions that we receive. So
there may be various answers in the various European jurisdictions. If you look at the various data protection authorities, they may give their own view. But I think you must never lose out of sight that GDPR is also built around accountability, which means if you want to do something, you have to be able to explain why you did something. And so it is very important to document what you're doing and to be transparent. And in what you do, to take into account also the proportionality principle, that you only do what is necessary for the purpose. And so I think that, I mean, Stefanie will say something about in which country they say X or Y. But I don't think that because the Data Protection Authority says on its website it's forbidden to do this or that, that this means that this is the law and you cannot do it. You have to always look at a specific situation and say, yes, but in my specific situation, can I do this? Can I explain? Can I document why I'm doing something? Do you have a roadmap to do that? Do you have, we talked about the privacy notice. Do I have good privacy notice to inform people about what I'm doing? And if then people accept to do that, even when you may be a little bit in the gray area, I think that then the risks are low, because in the end, as I mentioned in the beginning, we're talking about a confrontation between fundamental rights, and we are talking about an exceptional situation where actually there is no case law. We don't have any examples of, okay, this court has said X or Y, and in the end, it's not the Data Protection Authority. Okay, the Data Protection Authority can impose a fine, but you can still appeal to the court. And so I think that even in situations where it's gray, or where the Data Protection Authority in your country says, we don't think this is possible, that does not necessarily mean that in any and all circumstances you cannot do that. If you have good reason to do that, and if you think that it's important to do that for the health of the people, for instance, if the Data Protection Authority says, no, you cannot do that, but you as an employer, you are the boss of a hospital, or you are the boss of a home for elderly people, then you may say, yes, okay, that's the general rule, but in my circumstance, I want to apply it differently. I just wanted to say that before Stefanie tries to answer a few of your specific questions.
The US context for these questions is probably a little bit simpler than the European context for these questions. With respect to the first question, whether you can refuse the entry of a person who refuses to answer a health questionnaire, you as an employer and as an owner of a business, you have an obligation to maintain a safe work environment. And if an element of that is keeping or trying to keep people sick with COVID out of the premises, then yes, you can refuse entry. With respect to temperature checks, I started with this thought that we have to remember in which state we operate in. And many states have issued guidance where they actually state that any company operating in that state must administer temperature checks. There are states like that, for example, Colorado is one of those states. And then there are differences when it comes to treating visitors versus employees. For example, if you administer temperature checks, you have to do it in a consistent and an non-discriminating manner. So not just certain employees, certain groups. If you're engaging in temperature monitoring, temperature checks, then you have to apply them consistently in a way that makes sense for your workplace and not treat specific groups of employees differently. But again, for any company operating in the US, look at your state mandates. Some states require it, some states recommend it, but it's a state-specific question.
So for the EU, also for this question on whether temperature checks are possible, we see differences between the different EU countries, and there are also differences between visitors and employees. Again, there are countries with a very strict position on this topic, and then there are other countries with a more pragmatic approach and a more pragmatic position. Most countries with a strict position, they agree that the GDPR does not apply when temperature is only directly read and not recorded in a file. So, because in that case, there is no processing of personal data. It is important that measuring the temperature relates only to the reading of the result only, without any further processing of the results. And if that is the case, then many data protection authorities, they agree that a visitor, for instance, who is denied the access to the building when the body temperature is too high, without any additional registration of the personal data, that the GDPR does not apply to that situation, and that is really possible to do so. There are also DPAs, for instance, in the Netherlands, saying that the GDPR also does not apply when a visitor measures itself their temperature. In that case, the GDPR would also not apply, and that there are no further issues to that situation. But that brings us to the employees, and there the strict position of, again, Belgium, France, the Netherlands, they are of the opinion that it will be inevitable that a processing of personal data takes place when body temperature is measured. And as an example, they give that when a company, an employer, uses a system, for instance, where gates open or stay closed, or if you have a green or a red light that appears depending on the result of the temperature check, that this implies an automated processing of data, and that the GDPR will apply in any case. Also for employees, when you refuse access, you will have to justify your decision. And this justification implies, again, a processing of data. The same DPAs with a strict position, they say that when you use advanced digital measuring tools, for instance, digital fever scans or thermal cameras, that the GDPR will always apply in such case. So that brings us to, what if the GDPR applies? Well, then you, as an employer, you will need an exception. And according to these DPAs with a strict position, they say that there is no other exception possible, given that there is currently no law that explicitly allows the temperature checks. And the DPAs, they also emphasize that employers generally have other less intrusive measures available to create a safe and healthy work environment. Now, in our opinion, this position of these DPAs is too simplistic, restrictive, and not pragmatic, as they do not take into account the current exceptional situation. They also do not take into account legal obligations of the employer to ensure a safe and healthy workplace. And these legal obligations of the employer, which is in many European countries, and that's also the case in the countries where these strict positions are taken by the DPAs, for instance, Belgium, the Netherlands, etc. This legal obligation of the employer is set out in a national law on the well-being at the workplace. And in our view, this legal obligation, this law, could be sufficient could be a sufficient basis to allow body temperature checks. Moreover, when we look in practice, we see that already a lot of companies have implemented body temperature checks, and such measure is often supported and in some situations even requested by trade unions, the employees, or even the competent health and safety bodies of the company. So, in our opinion, there are sufficient arguments to say that the laws imposing a legal obligation to employers to provide for a safe and healthy workplace could be sufficient as a basis for body temperature checks. And if we look at the DPAs who have a more pragmatic approach, for instance, the British ICO and the Spanish DPA, we see that they indeed consider that the national well-being legislation can constitute an exception to the prohibition on processing health data, and therefore they consider that body temperature checks are allowed compared to the other stricter positions in other countries.
Okay, so we can let's maybe then tackle the two last of these small questions. So it was, can you oblige an employee to take a COVID test today or a vaccine tomorrow? And if yes, what can you do if they refuse? Can you terminate the contract?
The Americans with Disabilities Act basically states that when it comes to employers' authority to require a vaccination, there are two ways in which an employee, primarily two ways in which an employee can refuse a vaccination required by an employer. And one is health reasons. So in other words, there is a health condition that may result in a significant risk to the employee's health, and therefore the employee can refuse to receive the vaccination. Another is religious conviction. So in other words, a religious reason for the employee to refuse a vaccination. There have been a few cases here and there around the country where an employee has argued that they have a personal conviction, for example, for not taking vaccinations. But those cases are few and far between, and generally we can still say that only religious and health reasons are justification for refusing a vaccination.
For Europe, with regard to the vaccination, well, as there is currently no vaccine yet, the different national DPAs did not yet clarify their position or did not yet provide any guidance yet on whether or not employers will be able to oblige their employees to take a COVID-19 vaccine. However, if we look at the other positions of the DPAs on topics such as measuring of body temperature, etc., we think that some DPAs will probably hold a position that a vaccine cannot be imposed by employers. Another point that we also wanted to stress here is that most likely further guidance, instructions on the COVID-19 vaccine will be provided by each of the local governments itself. But to give you an idea, in the Netherlands, for instance, the Dutch government has already indicated that there will most likely not come a general obligation to take a COVID-19 vaccine. But the medical healthcare authorities who are responsible for the hospitals, etc., in the Netherlands, have on the other hand already indicated that there will indeed not be an obligation, but a strong recommendation for medical staff to take the COVID-19 vaccine. And that if some medical staff would then refuse to do so, that there will be strict rules, that they will, for instance, not be able to work in all divisions of the hospital, etc. So, and we assume that similar guidelines and similar positions will be taken by other EU countries. And then with regard to COVID-19 tests, for instance, before allowing your employees to enter the workplace, well, there again, you will know that there are various positions in the different EU countries. And again, some DPAs have a very strict position. Others are more pragmatic and really take into account the current exceptional situation. And to give you an idea, the strict positions are, as I already mentioned before, Belgium, the Netherlands, and France. And they say that without a legal basis, an employee cannot be obliged by his or her employer to take a COVID-19 test. However, they also nuance their strict position by confirming that for certain functions, it can be of importance that an employee is tested. For example, again, in the medical sector. Furthermore, it is also often emphasized by the DPAs with a strict position that COVID-19 tests can in no event be executed by the employer or someone of the managerial staff of the company. That if allowed, the COVID-19 test can only be carried out by the company doctor, and that the results of the tests can only be shared by the company doctor with the employee concerned and not with the employer. Another point that I wanted to stress here is that despite the strict rules established by the DPAs, it should be verified in any case whether there have been some guidelines, instructions from the national governments with regard to the testing. For instance, the Belgian government, and I assume that this is also the case in many other countries, has ordered that COVID-19 tests are mandatory for persons returning and traveling to Belgium from a red zone within the EU, the Schengen states, and the UK. So in such case, we are of the opinion that an employer could indeed request the employees who are returning to work after returning from a red zone to prove that they have taken a COVID-19 test, and that the employee shows proof, a document, but only showing it, that they indeed took a COVID-19 test, and that the employer will also only read what's on the document, but that the document itself is not processed. Also, and I think that's something that can help as a recommendation for employers in a country where the DPA has a very strict position with regard to COVID-19 tests, is that if you suspect a COVID-19 infection with one of your employees, ask and give the instruction to that employee to contact either the doctor of his choice and to follow further instructions from that doctor, or to refer that employee to the company doctor, who will then check if a test or any other measure is indeed necessary. And also, as a last point here, I think that employers should not forget that taking into account their general well-being obligations is that they can and they are entitled to send home an employee who is clearly sick, and that's in order to protect the other employees and visitors of the company.
One thing that I would like to add to the discussion around tests is the issue of antibody tests versus virus tests. So one of the issues that's been raised in the United States is many states have considered whether employers could be allowed to test antibodies, and the presence of antibodies would then enable those employees to return to the workplace without restrictions, because they've presumably already undergone or had the COVID-19 and therefore are at no risk. So far, states have taken a position that given the uncertainty around antibody testing and the potential risk relating to the uncertainties and how long the antibodies, the presence of antibodies can actually prevent the person from getting sick again, that you cannot implement a policy where having a positive antibody test that you would be allowed to enter the workplace. And so this is probably going to be an issue going forward until we have a vaccination, and this debate will continue.
Now, let's assume, and Stefanie started this discussion, let's assume one of your employees is sick. And actually, you have confirmation that this employee has COVID or had COVID. Typically, you will know who was on site the same day. That's why you track people in and out your building. How should you proceed regarding contact tracing? What can you disclose? Can you disclose the name of the sick person?
From a European point of view, again, you have countries with a very strict position on this question, whether you can disclose the name of sick employees to other employees. And there are countries with a less strict position, but those with a strict position, they say that you cannot disclose the name of the sick employees to colleagues. Of course, here again, they nuance their position, and they say that you cannot disclose the identity or the names of those infected, but you can, of course, inform other employees that there is an infection with colleagues at the workplace. Again, also here, we think that this position is again too restrictive, because in certain cases it can indeed be necessary for an employer, and this is again within the framework of the general obligations of the employer with regard to well-being, safety, and health at work. And in the absence of effective alternatives, that it could be necessary to communicate the names of infected employees, for instance, to the direct colleagues with whom the sick employee work closely together in a certain department, so that the necessary actions can be taken. And of course, the DPAs with this strict position, they also do not take into account that certainly in small companies, employees themselves will guess which of their colleagues are infected.
Given the complexity of the US state-by-state approach. Many companies have taken this position that, well, we have to remember, as I mentioned earlier, that the person's status of COVID-19 status is a confidential medical record and has to be kept separate from a person's personal file. And so companies generally do not communicate someone's positive test result to their employees, other employees, and the technologies adopted for contact tracing generally have been, and then for practical reasons, obviously the places where these technologies have been deployed have been places where people cannot work remotely, obviously. Factories, so-called essential workplaces that where employees are required to be physically present. So in such workplaces, the technologies that have been deployed have been based on, for example, individuals working in a certain area of the building, say, and then there's an automated signal if someone in that designated work area becomes sick, but at no point will it be disclosed who that person has been, just that everyone in that area who's been in the immediate vicinity of the infected person then will be notified and told to quarantine at home, say, for 14 days or whatever the period might be in that state, but generally it's 14 days. And then also, given the complexity of the state-by-state regulation, generally so-called tracking as opposed to tracing, where you are tracking the whereabouts of employees. Very rare is an employer who has deployed, say, a mobile application to track their employees and their whereabouts in the physical world outside the workplace. So workplace-specific solutions that are now allow anonymous notification of other employees in that facility have been the sort of the chosen method for many companies.
I would now like to continue the journey. So indeed, someone was infected, let's say in our example, and want to discuss and understand a bit better the risks involved and the liabilities of companies. So what are the risks and liabilities if someone got infected on your workplace, being it a visitor or an employee?
No, I think with respect to visitors, it will be the national rules on liability, the common law rules on liability that will apply in each European jurisdiction. So I think, in short, I think if you do not take as a company within your premises any precautions at all, and something happens, you're probably at risk for a possible liability claim if someone falls ill. If you do not take certain measures where these are imposed by local government, then you're definitely at risk, because then you're not only at risk of being sanctioned by the local authorities, but also, again, claims of individuals who got infected because you did not comply with local rules. If there are no specific obligations, I think to limit the risks of a possible claim is indeed not doing nothing, but is taking the reasonable precautions that we all know, is hanging out these posters with recommendations, asking people not to come into the building if they know that they are ill, putting these dispensers with disinfection, etc. So if you take all these measures and there are no specific rules that apply imposed by local government, I think you should be fine, and that's based on common law. I think with respect to employees, there may be specific risks and liabilities that Stefanie can maybe elaborate a bit more on, given the specific obligations as an employer, but also the specific obligations of employees themselves and their possible personal liability.
Employers have a legal obligation in many, and I think even all European countries, to provide for a safe and healthy workplace. So it is indeed important to take care of this and to implement the necessary measures to provide for such a safe and healthy workplace. And in many countries, employees, they can stay away from the workplace if there is a serious and immediate danger. So if they consider that the employer has not taken sufficient measures in order to avoid such a danger, the risk of a contamination with the COVID-19 virus will not be considered a serious and immediate danger only if adequate and necessary measures have been put in place by the employer. If the employer would decide to terminate an employee for refusing to come to work because there is a risk of COVID-19 in contamination, and if indeed insufficient measures have been taken by the employer, such termination could lead to an unfair dismissal. That's one point. Another point is that employees can not only decide to no longer come to work, but they can also file a complaint with social inspection authorities. And in many countries, currently the compliance with the legal obligation of the employer to provide for a safe and healthy workplace within the COVID-19 pandemic is actively monitored by inspection services. And if serious violations are detected by the inspection authorities, they are empowered to impose various sanctions, but it can go to the cessation of the activity, even the closure of the workplace, etc. So it's really important to provide and to implement the necessary measures. And in order to avoid any claim from an employee and or from a social inspection authority, we always recommend employers to well document the communications that the employer internally had with the company doctor, with the employees, with the trade unions, with other employee representative bodies such as Works Council, Health and Safety Committee, etc., regarding the implementation of certain measures, and that also that employers document the measures that they have actually implemented in the workplace, so that they really can demonstrate their compliance with their legal obligations. Then a last one, what if an employee is, for instance, sick, contaminated with the COVID-19 virus and refuses to go home and continues to come to the workplace, does not comply with the guidelines and the measures imposed by the employer? Can you terminate the employment contract? Well, we think so, because if an employee who refuses to go home when she is clearly sick, has symptoms of COVID-19 infection, this can be regarded as insubordination, because the employer has given certain instructions to the employees. For instance, when you are feeling sick, or when you're sick and when you have symptoms of COVID-19, well, you should stay home and you can no longer come to the workplace. If an employee ignores those instructions, that is first of all insubordination. Another point here is that if an employee continues to come to work, he knowingly and willingly refuses to comply with the valid instructions given by the employer, but he's also willingly and knowingly putting in danger colleagues, visitors, third parties, the employer, etc., in which case we think that the termination of the employment contract of that employee for serious cause would be possible. Of course, we will have to check that in the various EU countries, but we assume that in the majority of the EU countries, this will be the position possible.
Obviously, if you've been following the news, many companies have already been sued in the United States under various legal bases. Primarily, these suits have revolved around negligence and then sort of breach of so-called standards of care that companies have to take. But just to give you a brief list of the primary causes of action, then those are failure to properly screen employees for COVID-19. So in other words, not taking temperature tests, not asking not requiring questionnaires to be answered. Then failure to protect employees from other symptomatic persons. So in other words, again, not failing to screen people when they enter the workplace. All of those things that we've talked about throughout this webinar. And then failure to keep the workplace clean. So not having hand sanitizers, not cleaning high touch surfaces like elevator buttons, all of that. And then failure to provide PPE, personal protective equipment, if that is required in the workplace, or failure to implement social distancing policies, failure to implement the telework or work from home policy if that's an option, and failure to implement various government guidelines that we just talked about, all those state guidance requirements. And so that at the same time, there's a political battle in the Congress where employers would like protection from liability because these lawsuits will continue to be filed as this pandemic runs its course, and it'll be a challenging time for companies as they deal with these lawsuits.
We think that it is not very likely that data protection authorities will actively monitor what you are doing, so that the major risk lies in complaints of people who say, yes, they have asked me this, or they have said I have to do a certain check, whereas this was not allowed by law, and that they file a complaint. It's possible, it's very remotely, but for instance, in Belgium, we do have the Data Protection Authority that has, for instance, put on its website that it is investigating how the Brussels airport is dealing with temperature checks, and they have some questions about that, whether it's allowed or not. So you see that they are actively looking at this. So that's maybe something to be added in terms of, what are the risks we face when we process the data of an individual without being allowed by law.
Okay, very good. Well, thank you very much for all your
You're welcome. Thank you.
And replies. So maybe to the audience, we will send a link to the recording in a few days. We will also answer the questions that we received during the session. And we will also send a survey so that you can share your feedback, and so that we can see how we can make these sessions even more useful for you. So thank you very much, the three of you, and have a great day or evening. Thank you very much.